Hello guys, ladies and gentlemen, Kunjani, Sanmonani, how are you, wherever you are? All right. Senzo Meyiwa case. Senzo Meyiwa case has been postponed until April 15. The reason for the postponement are that Advocate Tulani Ngomezulu wants to go through. He wants to go through the testimony and the affidavits presented by the defense. As you remember very well that Ngomezulu came in just for the trial within trial, but then suspect number one decided to put him as his main attorney or his main lawyer, and he removed Advocate Ramosipiri. And this is not the first change. You remember that 2 years ago? Yes, 2 years ago, suspect number one and suspect number two removed Advocate Tobani. They removed Tobani and hired Advocate Ramosipiri. Okay, but before that, there was also another advocate. There was one advocate who was representing three of them. They were representing one, a first accused, second, and third were being accused by Tefo Manisela. That was the first, maybe the first lawyer when the case started. And then he was removed. And then came Tobani, was removed. And then Ramosipiri. And Ramosipiri was removed from suspect number one. Now he's only representing suspect number two. And Tulani Ngomezulu is now representing suspect number one. So what is happening now is that Advocate Ngomezulu requested the court to give him time to go through all the pages of the submissions from the defense in the main trial, because this is now the main trial. It's not trial within trial anymore. It's the main trial. So he wants to go through all the pages of the main trial so that he can see which points to argue. So on the day of postponement, they had just finished the hearing the testimony and evidences from testimonies from expert traffic, not traffic, but the vehicle registration, Department of what do you call NATIS, the Department of Traffic Registration or Vehicle Registration. Okay, his Superintendent Montreux was the one who was presenting the affidavit. Actually, I wanted to say something very important, because I've seen on the YouTube there are some posts that have been made by some people, and I think they are wrong presentation of what's going on in the court there. All right, this is very important. Of course, we are ignorant people, we're just YouTubers, but I wanted to make a point. Maybe some people can pick up what I will say. The first point is that every witness that is brought to court, okay, the state is bringing that witness for a purpose. Okay, the state is not just bringing witnesses anyhow. No, it's bringing witnesses for a purpose. For example, this witness Montreux, okay, was brought in. The state said it clearly about the relevance of this particular person. Particularly, more importantly, was to rebut and it was to vindicate. Okay, the state is findings that what they said, state what they had said, that the day that the days for the suspects, the the location of the suspects, their addresses at the time when the murder of Senzo Meyiwa was committed, because the suspect had said that they were not in that town where the crime took place. They were not in that particular town. So there in the court, we heard that the testimony from the NATIS expert, NATIS expert explained using the information from the computer, NATIS computer, where the information that was entered there, all right, through road driving tests, registration or application for license. That's what they say, learner's license for accused number 1, and registration of a car for accused number 4, and the booking of rented cars for accused number 5. So basically, accused number 1, number 4, and number 5. The NATIS expert concentrated on the 3 accused people. Their booking and the booking of the car, accused number 5. He had said he was not staying in that town during the time of the crime and was working in Joburg. He had said like that before, all right? But then the NATIS expert came with information about accused number 5 in relation to the entries of the cars that he was using. So there were bookings, traffic bookings by the police, road traffic bookings of the cars that he was using, some traffic offenses that were entered, and were within that period. It was a request from Brigadier Gininda, who said that the traffic expert, Mr. Superintendent Montreux, should investigate all the suspects, investigate them to understand, to know their history or their profile in regards to traffic activities. So that was made in the court, and we heard about it and about their home, Nongoma, and so on and so forth. So it's very important, because I've seen in the YouTube other people, they are making comments to say, oh, these statements were irrelevant, or this was not important, or whatever it is. But that is not the case, you see. And I also wanted to say the second thing is the line of questioning, or the line of interrogation, examination, From my understanding, lawyers are not supposed just to interrogate or ask questions just like anyhow. No, lawyers should be asking questions that have a purpose, to vindicate a point, to vindicate something else, But this is not the case. It looks like what is happening with the defense lawyers. They're just asking the questions, just asking questions that don't have any direction. Lawyers are not supposed to do like that. This is where I see that they're gonna have big problems. For example, Advocate Mshololo asked questions to the NATIS expert. I saw some posts and people are praising her for asking, but if you look at those questions, they don't stand in court, questions like those. Like, she is trying to take away, suspect number 5 from the scene of the crime, And she thinks like maybe she succeeded. But from my understanding, from my knowledge of the law, it doesn't work that way. It doesn't work with that way. You can ask questions like those, but they don't work. Okay. Let me say one thing before I forget that the state is supposed to prove the case beyond reasonable doubt. So the state can go anywhere. Even the judge said that the state has a duty to prove the case beyond reasonable doubt. But there are so many aspects of the case, and the state is not supposed to prove the case beyond reasonable doubt on all the aspects of the case. No, it's not like that. There are so many aspects that can only be vindicated or venerated by balance of probabilities. Balance of probability means that the most probable event to have happened. This is a crime scene. Okay? The court already knows that there are always attempts by the suspects, okay, to escape or to try to deny the obvious. The court already knows that. So the court uses balance of probability. It just establishes points, okay, that these points are true, okay. So then from there they connect the dots. It is allowed in the court to connect the dots in the case. Okay, this case, it's like this, like this, like this. Okay, then they connect the dots. So even if you try to ask questions like the questions Advocate Gomez was asking that, you know that after applying for the license, for the learner's license, okay, suspect number one may have or traveled, okay, the version of suspect number one is that he traveled to Nongoma, he traveled to KwaZulu-Natal, he was not around Gauteng, okay? But the NATIS expert said that the computer profile showed that suspect number one was actually, or after he failed the test, he applied for retest, okay, from Blackburn to Boxburg, okay, almost immediately, almost the same day. And then he passed the test. He passed it after a month, you see, which means that he surely was around. And they asked the question like about his address and said that the suspect just mentioned the address that was convenient to him, which is not true. And they said that's not what the law says. The law says that you must use your real address. And if there is any change in the address, you must inform the department. So, you see, those are points that have been proved. Okay, once the points are proved, the rest of other thing is just balance of probability. It's called balance of probability to prove that this is this story is true. Okay, you must differentiate between escaping a story, okay, and telling the truth. So in a case of law like this, what they want to do is to see the truth. If a person was not vindicated, was not involved in the crime, he must be a person who was not involved in the crime. Not necessarily that a person was involved in the crime but just wants to escape, okay, the case. Not like that. Because some people think like there must be loopholes. They must help the suspects to escape the case. That is not how court should operate. That is called defeating the ends of justice. So the other thing that I wanted to say, there is something they call in the law, there is something they call alibi. Okay, alibi is the defense of whereabouts. Okay, alibi is the defense of whereabouts. So I have seen, like, for example, Advocate Mshololo was trying to invoke alibi. Okay, even Ngomezulu is trying to invoke alibi to try to create a situation that the suspects were not the ones that were there. Okay, those suspects, the time that this crime was being committed, they were not there. They were somewhere. They had gone somewhere. They were not at that scene. Okay, that one is called defense of alibi. Defense of alibi works very well if you, as accused person, the time that you are being arrested, the time that you are being accused, okay, they give you the rights that you have the right to remain silent, whatever. All right, those. But when they're giving you rights, they don't mean you can't speak. Okay, no, you can speak. That is very important point, the important time to make very strong statements. Okay, that separate you from that crime. Okay, because they tell you that whatever you say here will be used in the court of law. Yes, okay, I am not guilty and I am not involved in any crime that you are accusing me. I am not, okay, and I am not accused of the crime, and I was not there. So even the time that the police, they give you opportunity to make statements, okay, you must not forget to mention those things, okay, that I was not involved in the crime and I was not there at that crime. And you give evidence, very strong evidence, not to lie, but to say the truth. You give evidence. If there are witnesses, you mention some people that the police must interrogate or ask or list as witnesses to venerate or vindicate that you were not there at the place of the crime. Okay, or that you are a wrong person that they are looking for. So you give evidence that, for example, if the police are looking for a person by this name, okay, you show your ID that you are not that person. Okay, ID number, the people that they are looking for, and your ID number must be different. Your place where you were born, or where you have been, or school where you went must be different. They must be totally separated, facts, okay, that must be collected, that you must submit, must be different from what the police are looking for. It's possible really to arrest people that are wrong, okay, suspects, but it is very recommended that at that particular time, that is the time that you must make very strong statements, okay, to deny that charge, and don't lie, but say the truth, that if you really are not guilty, or you are not the one that they are looking for, you have to make that straight statement and give them the characteristics that, or the evidences, preliminary evidences, for them to get the point, to understand that you are not the one that they are looking for. Maybe you are just a wrong identity. Okay, so that is very important. But the suspects, Senzo Meyiwa suspects, missed all those opportunities. So now what is happening? They are bringing those statements now, okay? So it's late, okay? It's very late. They are late to invoke alibi defense. They are late because when you invoke alibi defense later, okay, it is called afterthought. Afterthought, it means that you sat down, you thought about it, and you created defense, how to defend your case, what. The court already knows that people create afterthought. So afterthought doesn't carry much weight. Even if you speak, for example, you saw as suspect number one, he came up with a version that is different from Gininda's. And there is what is called docket number 365. That one is exactly what I'm talking about. Does not carry weight because it's called afterthought. People create a story in order to escape a story. So what I'm trying to say is that docket number 365, okay, to me is like a docket of, okay, investigated by lazy police, okay, lazy investigators, okay, because it just talks about people who were in the house, only that. You see, it's not broad enough, it's not rich enough. There's no way criminals can be as cheap as that. Criminals are very intelligent people. They know how to plan. They plan so well, and they create the whole idea on how they're gonna escape that even before they execute their plans. You see, so a crime cannot be as cheap as that, as simple as that. The way it is maybe explained in that docket, so-called docket 365, it was actually investigated by very, very lazy, investigators. That's why even the state could not even pick it up, because criminals who can do that kind of crime cannot be as easy as that. That's just the people who were sitting in the house and then they agree to shoot someone just like that. It cannot happen like that. It must be a very well executed plan that had happened. And that's why the state had to go deeper to find those things. You see, the caliber of the witnesses that were brought there, including the police people were brought there, including underground police that were there. See, underground, including where the firearms were taken, including Inyangas, you see there, and then all the addresses, including bank details, bank statements, see, including money bags and all of those things. That's how they investigate a crime. They go deeper and deeper and deeper, deeper and deeper like that. So, talking about the alibi, defense of whereabouts, okay, I think that Msholo was trying to invoke that one so that she could perhaps, defend her client. But the way it was presented, one was a wrong time, because such a statement was supposed to be made, okay, was supposed to be made to police the day the suspects were arrested. And you cannot say today that, the cars were wrong. They were wrong colors. They were wrong this. It's late to say like that, because the problem, the big problem now is that the judge, he allowed the confessions, okay? And those confessions, he said that the confessions were done freely and fairly. And now in the confessions, all the suspects, they are put on the crime scene. Already they are on the crime scene. So what the defense lawyers are doing is to take out their clients from the crime scene, which is very difficult, because that was supposed to be backed by the initial statements from the suspects themselves, the time they were being arrested. Okay, that's the time it makes it carries more weight. When you're being arrested, that's the time, even if they say you have the right to remain silent, even if they assault you or what, you provide evidence to the police, statements, you say it clearly, and you provide proof that you are not the one that they are looking for. Okay, that because when those police people are called to make statements, they will include your statements, what you've made, and it becomes more powerful because you made it at the scene of arrest. So guys, thank you so much for watching my channel, for following my channel. Please subscribe, and let's share views together. I'm not saying these views are absolute truth, but I know that this is how things work. Okay, some of the YouTube channels, they are misleading people because they're just trying to be populist. Okay, I've been vindicated in so many events in Senzo Meyiwa case and AKA. And I repeat to you guys, watch this one and listen to me. What I'm telling you is likely what's going to happen. Thank you so much. Bye-bye.